I don't believe you. I think I'll tell you what I think's happening. I think you're trying to get yourself off of the drug. You were taking the Suboxone. You have an opiate addiction. You were taking the Suboxone. You want to get yourself off of the Suboxone. That is clear. You want to have yourself clean, and you had a moment of weakness. And that's why an opiate is showing up. Now, you can shake your head all you want. I've been doing this for a long time. And you can come in here and then try to show me something that you say shows up as an opiate. Our testing is so sensitive. Court recalls the case of the People versus Deion Lyons.
Then on behalf of the people.
And again, y'all are Attorney Kevin Masson, P71061 on behalf of Mr. Deion Lyons. Mr. Lyons, state your correct.
Deion Lyons. All right, we have checked and shared with counsel sidebar. I'm looking for their actual written response. Which is what I kind of suspected. There's one drug in here that may show up as opioid, but would not be picked up on our test. That's a simplified version of the answer. Would not test positive on our test as an opiate. And specifically, Community Corrections informs me this is not an opiate drug, mainly because selling that at a gas station would indicate that that gas station would be charged with a felony. They were selling a narcotic. But then additionally, specifically, they very clearly indicate it would not show up on our drug screen as an opiate. So, how many of these supposedly did you buy?
So, you want me to respond, Judge?
Yeah.
So I talked to my client, Judge. He said he was taking them for 5 days straight, yeah.
Well, all right.
And may I address the bond issue, Judge?
Yes, you may.
And so, first and foremost, I don't think Mr. Lyons is trying to evade the court in any way, shape, or form. I did have a in-depth conversation with my client, and Judge, he's still adamant that those were the only any type of drug or I don't want to say prescription, but those are the only things that he has consumed. And I know what the court's position is. I know what the test says, but my client is adamant that that's it. What I would note, Judge, is that prior to this test, he had tested negative. On the 10th, he tested positive for opiates. However, he tested today with Community Corrections, and from my understanding, it was negative. That there's nothing in the system as of right now. My client is adamant that there will be nothing in the system going forward. I know that a report showing that he had opiates is technically a bond violation, but my client has been trying to wean himself off of any type of narcotics since the day he got tested, when he had the Suboxone in his system, which is clearly no longer in his system. He stopped with the THC and the marijuana. That's why no THC is in his system. And now we're left with this particular incident. And so, Judge, I guess what I'm asking the court for, given the fact that he did technically test negative today, if the court would give him one more opportunity to prove himself that he can stay clean, that he can stay negative, and not consume any type of narcotics of any sorts from this point forward. I believe that Mr. Lyons will do so. His mother is scheduled for a major surgery where he is set to be her caretaker. And so I'm hoping the court will continue his bond to allow him to do that as well. But with that being said, Judge, I'm asking the court not to revoke Mr. Lyons' bond, but to give him one more opportunity to prove to this court that he can stay negative with his testing. Yeah.
Anything from the people?
I have some concerns. I know the last time we were here, we had some concerns about the Suboxone, given they didn't have the prescription, and we're working through that. And I understand that. I'm concerned now that we're here. It's opiates. Community Corrections says they don't match with what the test results are showing. the product that he brought in, so I have concerns. That one.
As far as the case, what do we want to do on the case?
Defense counsel is prepared to set it for a preliminary exam.
I won't, here's what I'm gonna do. I'm not going to at this juncture set it for preliminary examination. I'm going to adjourn the probable cause conference out 1 week. February 26, 2026 at 9, or as your Zoom invite indicates. At that time, I'm also, if you want, I will set a hearing on the bond violation. I'll get the people over here, let the prosecutor know. I'll get the people from community corrections to testify if we need to regarding that drug and what shows up on their test results. I'm going to indicate to you, young man, I'll be honest with you, with what I know right now, I may learn something later. I don't believe you. I think I'll tell you what I think's happening. I think you're trying to get yourself off of the drug. You were taking the Suboxone. You have an opiate addiction. You were taking the Suboxone. You want to get yourself off of the Suboxone. That is clear. You want to have yourself clean, and you had a moment of weakness. And that's why an opiate is showing up. Now you can shake your head all you want. I've been watching, I've been doing this for a long time. And you can come in here and then try to show me something that you say shows up as an opiate. Our testing is so sensitive. I mean, our testing distinguishes between heroin, fentanyl, and an opiate. We can distinguish all of those different drugs as to what somebody's taking. And so this product would not show up as an opiate. And at some point, quite frankly, you're going to have to come to the realization that, and I think you're an addict. And you're going to have those moments. But the problem is, when you have those moments, you're going to have to be honest about it. And I don't think you're being honest right now. And I think there may be other reasons why you're not being honest, but you're not being honest. Because the only way that you're going to manage your addiction is if you are honest. So I will set this for a hearing. Counsel can let us know if he really wants to go forth with the hearing, but people would be expected to have the people here. I've set it out 1 week actually I'll set that at 3 p.m. for the hearing. I'll set his PCC also at 3 p.m. At this point, however, your bond is revoked. Defendant's remanded pending that hearing.
Good afternoon, Your Honor. Deborah Schlossel on behalf of the defendant, Adam Allen. Can you state your name?
Adam John Allen, Your Honor.
Thank you.
Your Honor, I have discussed this with the prosecutor. We're in negotiations. We'd like to see if we can get my client admitted into sobriety court. So we would like to adjourn this matter. What, 30 days? I think maybe 30 days.
Which court?
So, Your Honor, he lives on the east side of Detroit, so I was thinking either St. Clair Shores or Warren because those are closer to him.
Yeah. He's in Wayne County though, right?
Correct.
I need a green sheet filled out. I'll give you the adjournment. I'll adjourn this matter to March 19th. 2026, 9 a.m. Urge your invite indicates bond will continue.
Thank you, Your Honor.
Thank you.
I do have another matter. I don't know.
Bye.
I do have another case. Oh, no, wait. I do have another case. I don't know if you were, or should I be seated and wait?
How does that work usually? No, how does that?
I'm sorry, Your Honor. It's
No,
been a little.
I've got another one here. I don't know. Did I change something, Alan? Okay.
I
didn't think so.
Court does call the case People versus Joshua Steuben. And see, I knew it was going to be the next one, but I was going to make you go back there anyway, because I only had one case.
Deborah Schlossel on behalf of the defendant, Mr. Joshua Steuben. Your Honor.
State your name, sir.
Joshua Steuben.
Thank you.
Sorry, Your Honor, I'm a little off guard. Your Honor, we also would like to adjourn this matter out 30 days for the purpose of plea negotiations.
Any objection from the people?
No, Your Honor. Also, know there's some media that I need to get to defense counsel as well. We have that. I just need to make the meeting.
I said that one for the 19th.
That is correct, Your Honor.
March 19th, 2026.
Thank you, Your Honor. I will fill out
9
a
a.m.
Zoom form for.
Bond will continue. And I don't think you have another case because I don't have any more files.
No, I
from that
don't.
block. So you're good. I'll need a green sheet on both.
All
of
right,
these.
thank you.
Your Honor. Anyone, they're not here yet.
This attorney. Sire. Justice Pan tried to file the suit request late and I didn't talk. So I have not had contact with him.
Court calls the case People versus Francisco Joseda Lara.
And Assistant Public Defender, Your Honor, on behalf of my client, Judge.
I extremely apologize, Your Honor, for showing up late.
Your name?
My name is Francisco Andres Casale.
Your Honor, I know the court would like to address the bond violation first.
Yes. There a particular reason you can't test on time?
I'm sorry, Your Honor. I try to do it just with having kids and I'm in a busy life as a single dad. It's kind of hard to take track of the times, but I will be more on top of it. You give me another chance.
Did we set an order on this one? Or we just got?
No, we just got that yesterday, Your Honor. This is the first violation.
And Your Honor, I've spoken with Mr. Cazetta Loretta, and I asked the same question that the court did. He indicated to me that he thought that as long as he got the test in, that he would be fine. I told him that these time blocks in which he's supposed to test
I
by.
don't know what that meant. As
As
long
in-
as he got a test in.
As he's supposed to test between 6 a.m. and 9 a.m. and he tests at 9:18 a.m. because the majority, if not all of these, are for late tests. I tried to look through every last one of them. I don't think that there were any. There were a few missed tests very early on in December.
I
But-
guess I'm unclear though as to why, if I give you 3-hour windows, you can't find the time in those 3-hour windows to test.
Your Honor, he explained to me that he has been extremely overwhelmed with his children, his work schedule, which is those are the different reasons that he's been testing late. Sometimes he wouldn't even have the device on him when he was at work or elsewhere. I told him that this is a very serious situation. I would say that the positive is that he has not had any positive tests. And I know that weighs a little bit because obviously the court has required that he test timely. I have spoken with him. He informed me that he's currently on probation out in Kent County in Kentwood. I did supply the court with another document. I spoke with his probation officer in Kentwood, and she states that he is currently testing with them 1 to 2 times weekly. He's doing ETG tests as well as it's a dipstick test is how she described it. And he's doing the ETG tests and it tests for drugs and alcohol. I have provided the court, I asked her to submit a write-up explaining the results of those tests. She did submit it to me. I forwarded it to his community corrections agent, and I furnished a copy to the court as well as the people
When was that?
today, Judge.
Did we get something from?
Yeah, it's in the file. And what you're gonna be ready.
Yes.
It's right here.
So, Your Honor, and I asked specifically, I know in the initial paragraph, she describes the type of testing that he's currently doing, but in the body of it, it does not say alcohol. She says that if it does not say he's positive for alcohol, then he has not tested positive for alcohol. And she has confirmed that all of his tests have been negative. He does have the positive THCs, but he has a medical marijuana card.
Justice has two failed to appear.
So the two failed to appear. He's telling me that he was in another court that date. I'd have to confirm the dates, but Your Honor, he did not start testing in our court until 12/12 is when he was required to begin his testing. So from the time frame that he's been testing with us, he has been very consecutive with his tests in Kentwood as well. And he has been negative for everything there, except for the positive THC, which he has the card for.
Can't seem to do anything on time. Why was he late today?
Your Honor,
Your Honor, I was late coming over here. I stayed out in Grand Rapids, so I had to pack my family up and I took off. And right 30 minutes before I remembered about my apparatus and the test, so I turned around, ran home, did the test, submitted it. I brought the apparatus with me just in case. I deeply apologize for the time frame, sir.
and Your Honor, typically the court has been very generous in allowing him to log in on Zoom. I think the court can remember when this case was first called today, I informed the court that we did not make that Zoom request because we knew the court would need him here in person to address this.
And you're asking for an adjournment.
We are, Your Honor. I'm in communications with the people in regards to a resolution.
All right, we'll be sending an order out indicating that you are not to have any more visitors. Yes, that's how I'll handle this unless you want me to switch over to a Scram unit.
And Judge, I did speak with him about a Scram, and I think that that would be best with his
With
small
the
children.
okay.
Judge.
All right. Then we'll switch him over to a Scram testing unit.
So thank you, Your Honor.
How much time did you?
I think 2 weeks would be fine, Your Honor.
Probable cause conference will be adjourned March 12th, 2026, 9 a.m.
Thank you, Your Honor.
Bond will continue. With
Thank you.
the change in it being the Scram unit. You can head over there now if you have the other one to turn in.
Okay, thank you, Your Honor. I will do that surely right now. Thank you, sir. Have a good day.
Thank you. Court calls the case People versus Lawrence Ransom.
Assistant Public Defender Chinazi Carey, I can really, Your Honor, on behalf of Mr. Lawrence Ransom. Mr. Ransom, state your name for the record, please.
Lawrence Ransom.
Your Honor, we're
And
asking.
where was he?
Judge, Mr. Ransom indicates, and I think I told the court earlier that I had not had contact with Mr. Ransom, which was true. But he states that he called my office and they told him that his court date was scheduled for 1:30. So I don't know. I will find out. I'll get to the bottom of it, where this incorrect information came from.
To see, I'll call you out stuff. She don't answer the phone. She don't answer the phone for me. That's what I'm thinking. So how come you didn't answer the phone when he called?
I don't believe he called me. Did you call my phone?
I called I don't have your phone number. I called the office. They told me to come at the same time I've been coming last time, and that was 2:00. I got here at 1:25. So, trying to be early, but
So they told you just to appear the same time you did last time. And that's what you did.
no, I was here.
You were early, but I mean, your intent was just come at the same time last time.
No, that's why I came early. I came at 1:25. I was trying to be. They said 2:00. I was trying to be 45 minutes early. I was trying to be earlier than that.
So he doesn't do good in math either. Because you got here, that's not 45 minutes. You're good. It's not you I'm worried about. It's like what communication is getting through.
I will get to the bottom of it, Judge.
Okay, you get to the bottom of it. Otherwise, what's gonna end up happening is you're gonna have your client's bench warrant that.
No, I am
Right.
so, thank you so much, Your Honor, for
Because
recalling.
if I asked him right now, would you want me to lock him up or you? I bet you he's gonna say you.
No, he.
Yes, he would. Yes, he would. Oh. I'll cancel the bench warrant.
Thank you so much, Your
Hey,
Honor.
shoot. Huh? Carol? No. You want an adjourn?
Yes, please, Your Honor. We're trying to, he's out of county, so we're working on getting him into a sobriety court in Wayne County.
Oh, okay. So how far along are you on that process? Because
We're just starting.
yes. Which part of Wayne?
He lives in Canton, Judge, so.
So at least he's on the air. Okay. Let's do it this way and then. And I'm gonna put it 30 days out.
Okay,
And so you can start that process and see what can happen on that.
thank you very much.
So I'll set it for March 19, 2026. Okay,
Thank you, Judge.
and sir, I joke about it, but thank you for coming early and trying to be proactive on it. I do appreciate it. Yes, absolutely. Always try to do what I can for you. You know, and I did today.
You did.
I did today. Because yesterday was Random Acts of Kindness Day. I decided to postpone it until today. And so these things I did for Acton Ridley were just random acts of kindness. Kinda.
It's not on your.
No, it is. No, it was. It was. I'm holding it.
Thank you very much.
Why you say that wasn't? It was on the calendar. Well, I don't know if it was on the calendar. Alexa told me that's what day it was. Yesterday, my whole day was random acts of kindness toward you. You okay? All right, never mind. That was pushing it. Wow. Everybody just turns on. Court calls the case, People versus Jessica Williams.
Neighbor Children's appearing on behalf of the people.
Your Honor, Justin's aide on behalf of Ms. Rose, I think she just stepped out of the bathroom.
Pass it.
Pass, thank you.
Court calls the case, People versus Deanne Lyons.
And then on behalf of the people, Your Honor.
And definitely, Your Honor, Attorney Kim, 71061, on behalf of Mr. Deion Lyons. Mr. Lyons, state your name for the record.
Beyond Lions.
And good one. All right. Did council have a copy of this?
Is that the bond report, Your Honor?
Redwood toxicology report?
I have that, Judge. Well, this is what I have, the progress report, Your Honor. That's what I have. Yeah, that's what I have as well, Judge.
So you don't have the Abbott Laboratories report?
I don't have it either.
I'll get copies for them. So let me pass the matter so you can go through that with the client.
Thank you, Judge.
We're waiting on the other. Who's here? What are you talking about?
Find this client.
We're waiting for his client. I already called it. Where were you?
Honestly, I have no idea.
Same all the time things.
Just, you guys need to keep up with me. Alan just turned on me at least 3 times. 3 times during that whole thing. You could have stuck by my side. No, that was yesterday. I did. I was doing random acts of kindness everywhere yesterday.
Yesterday?
Isn't that right, Mr. Bates?
Yes.
See? That one.
Yeah.
See, Bates agreed. What? But he felt the random acts for where he was. See? Some people just don't appreciate it. No, I got stuff to. Court recalls the case People versus Lyons.
And again, Your Honor, Attorney Kevin Bassan, P 71061 on behalf of Mr. Keon Lyons. Mr. Lyons, state your name for the record.
All right. All right. I gave them reports over.
I did review the report, Judge, for probable cause purposes, though, Judge. We did receive all the discovery, and we're prepared to set this matter for a preliminary exam.
All right. People have anything to say regarding the reports?
Your Honor, I don't on the lab report, I do have concerns of this new test that it is positive for 4 weeks. And I know Mr. Bissett sent a I don't know what. Maybe about.
Yeah. Court recalls the case People versus Jessica Williams.
Good afternoon, Your Honor. Justice Aid appearing on behalf of Ms. Williams, present standing to my right. Can you say your name?
Jessica.
Sorry.
Apologies, Your Honor.
Good job. All right. I have before me, did you state your name, ma'am?
Jessica Williams.
All right. I have before me a plea form that indicates that the defendant would be pleading guilty to an added count 2 of disturbing the peace, a 90-day offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of it.
That's correct, Your Honor.
May I have her sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name, please.
Jessica Williams.
All right. Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of disturbing the peace. That is a misdemeanor punishable by up to 90 days, $500 fine plus court costs. You understand that?
Yes, Your Honor.
In understanding that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
You understand that with pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
September 25th, 2025, at the location of 1150 Paddock Place, Pittsfield Township, Washtenaw County, State of Michigan. What did you do on that date that makes you think that you're guilty?
I was in an altered mental state and I
Pardon?
lunged. I was being cared for by an EMT in an altered mental state. And at one point I lunged toward an EMT
Okay.
in the ambulance and acted inappropriately.
And the altered state was an voluntary state?
Yes, sir. Yes, sir.
Okay. And when you did that,
lunged at the EMTs and didn't cooperate with them, it disturbed the peace and repose of the immediate area surrounding you?
Yes, Your Honor.
Ma'am, if I accept your plea, I have to advise you that if between the time of the plea, or from the time I accept the plea and the time of your sentencing, that if you commit misconduct as defined under the Michigan court rules, that you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Oh, yeah.
No, Your Honor.
Hold on a second. And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered. Sentencing in this matter will be March 11th, 2026, 9 a.m. That's before me. Counsel, approach briefly. Your offense. On his successful plea to that charge, count 1 would be dismissed and the sentencing judge waiver is checked. That's the court's full understanding of the agreement.
Your Honor, that is accurate. Would just add as part of a resolution that involves the defendant's other case. He's waived up on that one. And you can fight up on that. I didn't put that on the form because it's a different case, but it's part of.
But he's not seeking HIDA on this case.
He's not HIDA eligible.
He's not, I got it.
3 days past eligibility. Just had a birthday.
Got it. Okay. All right. Let's have him sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
State your name.
Malik Robertson.
All right. You can put your hand down. Sir, it is this court's understanding that you're going to plead guilty to the charge of attempted resisting and obstructing a first responder. Is that correct?
Yes, Your Honor.
All right. That is a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Garwood in the 15th District Court. You understand that?
Yes, Your Honor.
Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
You understand by pleading guilty, you'll not have you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
Oh, Your Honor.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you're guilty of this offense?
Yes, Your Honor.
On the date of January 2nd, 2026, at the location of 2749 Adrian Drive, City of Ann Arbor, Washtenaw County, State of Michigan, did you come into contact with police officers from the Ann Arbor Police Department?
Yes, Your Honor.
What happened?
I was told some rules. I was given the order and then followed.
Okay. What order were you given?
To leave the premises.
Okay, so you weren't supposed to be there?
I was. I was coming to grab my things.
Okay, so let me ask you this. Why was the officer asking you to leave?
Your Honor, the officer was asking him to leave so that things would calm down. To leave 2 hours for at least 2 hours or 24 hours.
Okay, so that's, I suppose. So at your home address, the 2749, that's your home, right?
At the time.
Not anymore. At the time it was.
At the time it was, that's right, okay. Something was happening in the household between people in the house. That be
Yes.
fair?
Yes.
All right. One way or another, police get called,
Yes,
right? And they give you a lawful order to try to diffuse the situation, telling you to leave the premises.
yes, Your Honor.
And you would agree that that would have been a lawful order or command on their part, given the circumstances.
Yes,
And you refuse to do that.
yes, Your Honor.
And so when you refuse to do that, what happened?
Um,
Yeah, not a good thing, huh?
yeah, not a good.
Yeah, it didn't work out for you, did it?
Not for
It
real.
would have been better just to listen.
Yeah.
Yeah, okay. All right. Sir, if I accept your plea, you want, and you knew, I should ask you, you knew that they were officers acting in their lawful duty, acting in
Yes,
their
sir.
lawful duty. All right. Sir, if I accept your plea, I do have to advise you that if between the time I accept your plea and the time of your sentencing, if you commit misconduct as defined in the Michigan court rules, that you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. Do you understand that?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None, Judge.
And have I complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count two. Count one is dismissed. A pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
March 17th at 9 a.m.
March 17th, 2026, 9 a.m. before Judge Garwood. Bond will continue. All right. Thank you, sir.
Thank you,
Judge,
Your
I
Honor.
just wanted to make sure.
Oh, I don't have another date, so you.
Okay, so I'll take it up with them. Thank you, Judge.
Thank you. Court does call the case. People versus Rita, is it Giddick?
People.
Good afternoon, Your Honor. Steve Tremontin with and on behalf of the defendant, Dr. Rita Giddick. Dr. Giddick, could you state your name for the record, please?
My name is Dr. Rita Giddick.
All right, thank you. What are we doing?
We're asking for an exam date, Your Honor. Best March.
Discovery is complete.
Correct. I have not been informed that there's any discovery they have that I don't.
And would people have their witnesses available the third?
Yes.
Preliminary examination in person will be set March 3rd, 2026, 9 a.m. before Judge Freshour. Bond will continue. Thank you.
Thank you, Your Honor. Have a good day.
Court calls the case of the people versus Lisa Keebler.
Over the house with and on behalf of Ms. Keebler here for the first probable cause conference after her arraignment. Please just state your name for the court.
State your name.
Lisa Keebler.
Thank you.
There is a green sheet adjournment request in the file for ongoing discovery evaluation. This is really Mr. Shea's case much more than mine, and he couldn't be here today.
Yeah, I understand that. Do you say how much time he
He was looking for 3 weeks, March 12th.
3
please.
weeks, March 12th. No objection. Probable cause conference then will be adjourned March 12th, 2026, 9 a.m. Bond in this case will continue. All right, thank you.
Very good. Thank you.
Court does call the case, People versus Ethan Jordan.
Afternoon, Your Honor.
And good afternoon, Your Honor. For the record, Orlando Simone, Student Legal Services. On behalf and with Mr. Jordan. Did you say your name?
Ethan Jordan. Thank you.
And Your Honor, we put in a request for a brief adjournment. I'm still looking for some additional discovery, some body cam. Talk to Mr. Cook. We should be able to get that and take a look at it.
And Your Honor, we have that. It just needs to get to Mr. Orlando.
Got it. 12th work.
We're good with the 5th. If you prefer the 12th, we can do the 12th.
You want the 5th? What do you want? What day you want? I don't usually ask that. You want the 12th or the 5th?
I'll take the
Pick a date.
I'll take the 5th.
Thank you. You'll take the 5th. Yeah, you just got that. All right. March 5th, 2026, 9 a.m. All right.
Excellent. It's too big of an opening.
Yes, it was. Fine, we'll continue.
Served
Thank
it up
you.
nicely. Thank you.
Good seeing
Good
you.
to see you.
Thank you.
Thank you. Court calls the case, People versus Haley Garcia.
Afternoon, Your Honor, Raymond Cook of People.
Okay.
And good afternoon, Your Honor, Attorney Maxwell Rubin, P number 86012 on behalf of Ms. Garcia, who appeared via Zoom.
Garcia, can you state your name, please?
Haley Garcia.
Thank you. You know something? Dubin is always in his car. It's like really weird. I mean, I don't know. Does he live there or something?
Your Honor,
Well, no, it's okay. We'll take a collection up and we'll figure it out. All right.
I might as well live in this at this point in time. So I appreciate someone notices. Thank you. Tell my partner.
Yeah, right. Okay, what are we doing?
Your Honor, I believe that the people still need more time to just get the proper paperwork in. We do have a resolution. I think they would require an adjournment just to get the proper paperwork in for the
All right.
And that was just, the plea form was sent to defense counsel, so as soon as that all gets signed, we should be all good to go. We just need a date.
All right, you want 1 or 2 weeks?
1 week is perfectly fine, Your Honor.
You're gonna be out of the car?
Probably
Never mind.
not.
You don't have to answer. You don't have to answer that. None of my business. All right. Probable cause conference, I will adjourn it to February 26, 2026, 9 a.m. or as your invite indicates, bond will continue. All right.
Thank you, Your Honor.
Thank you,
Great
folks.
to see you.
Thank you.
Bye.
Court calls the case, People versus Adam Allen.
Good afternoon, Your Honor, Raymond Cook of People.
Ready, Your Honor.
A routine court docket quickly turns into sharp, fast-paced exchanges as multiple defendants step forward, some requesting preliminary exams, others entering guilty pleas, and several asking for adjournments to review discovery or finalize plea agreements. Bonds continue, dates are set, and the court carefully confirms each defendant understands their rights before moving cases forward. One defendant waives a preliminary exam and pleads guilty to attempted resisting and obstructing after admitting he ignored a lawful police order meant to calm a situation at his home. Another seeks permission to travel out of state for work while on bond, and the court agrees pending a formal order. Case after case, the message is clear. Understand your rights, know the consequences, and be prepared when you step into court. So here's the question. When facing charges, is it better to fight at preliminary exam or resolve it early with a plea? Like and share if accountability in court matters.